www.nvlsp.org. So if you don't catch this information today, it'll be up on our web. I do want to say that we do not take all cases. We screen cases and can only take a limited number. We require people to assist us in signing the releases so we can get files, which we review. And so people should feel free to apply for our services. And if we feel that you're a good fit for our program, then we would provide representation through a pro bono partner at no cost to the veteran. And I'm going to turn it over. I believe David is next.
Thanks, Rochelle. Again, I'm David Sunshine. I'm a senior staff attorney at the National Veterans Legal Services Program. Thanks to everyone for attending today. Now we're going to move into more of the substantive part of the program. We're going to discuss the military disability retirement through the integrated disability evaluation system. Next slide, please. So first, let's discuss what is a medical retirement. Well, a medical retirement is issued when a service-connected medical condition is severe enough to interfere with the proper performance of one's military duties, and that injury is rated at 30% or more by the VA. So you essentially need two things in order to be medically retired from the military. You need to have an injury or injuries that cause you to not be able to perform your military duties. And you also need to have those injuries be rated by the VA at 30% or higher. So if the conditions are rated at 30% or higher, then you would receive a military disability retirement. If the conditions are rated less than 30%, then you would not receive a disability retirement. You would receive what's called a disability severance payment, which is a one-time lump sum payment provided by the military for any conditions that make you not be able to perform your duties. But again, those injuries did not amount to a 30% rating. Now, a medical retirement compensation is different from VA disability compensation. So the military is only going to provide a medical retirement and only going to compensate a veteran for conditions that bring about the end of their service or the end of their career. On the flip side, the VA will provide disability compensation for any injury that was incurred or aggravated by military service. And so the distinction there is that the military, again, is only looking to compensate for injuries that cause the service member not to be able to perform their duties. Whereas, again, the VA will look to compensate for any injury that was caused by military service. And so we often see, veterans have a lot more conditions that are service connected and compensated for by the VA than, what the military may compensate them for in a disability retirement. Next slide, please. So the benefits of a medical retirement. Essentially, a medical retirement bestows the same benefits that a service member would receive with a 20-year retirement. So the benefits are the same for a disability retirement and also for a longevity retirement. Those benefits would include military health care called TRICARE for the veteran, his or her spouse, and his or her children until they reach the age of 18. A medical retirement would also provide a monthly payment or stipend that equates to the veteran's disability. So essentially, if the military assigns you a disability rating of 30%, then you would potentially be entitled to receive 30% of whatever your base pay is. A veteran would also receive a retired military ID card, which would allow them to enter military installations and have access to the commissary and base exchange and all that good stuff. There are also other, state and local benefits that are available to medical retirees that are not listed here. So now I'm going to turn it over to Esther to discuss how somebody obtains a medical retirement.
Thanks, David. So the benefits are pretty great if you can get a medical retirement. So the question becomes, well, how do I obtain one? Or if you're advocating for someone, how do I help someone obtain one? And there are two ways, as my colleagues previously mentioned. You can do it in service through the Integrated Disability Evaluation System. So a physician has to refer you for a specific condition into the process, or you can do it post-discharge. You get out and you either say, my process was wrong, or I never got the process, and you can apply for the board, apply to the Board for Correction of Military Records. And if you actually had process, you could go directly to court. And then there's a separate board called the Physical Disability Board of Review, which is only for members separated between September 11th, 2001 and December 31st, 2009 with IDES processing. Next slide, Matt. So what we're going to talk about, or I'm going to talk about right now, is the Integrated Disability Evaluation System. So that's your in-service disability processing. It's a joint process by which the VA and the DoD determine whether a wounded, ill, or injured service member is fit, and that's the key word, fit for continued military service. The Integrated Disability Evaluation System, or IDES for short, is integrated because the VA examinations occur at the start for all referred and claimed conditions. And what this means is that if your physician refers you for your mental health condition, you can claim 50 other conditions that are service connected. That doesn't mean that you think each and every one of them prevent you from doing your job. It just means that you believe that they're all service connected. And then you get an examination from the VA, which is used by both the DoD and the VA for different purposes. After you go to your VA examinations, you will go through a medical evaluation board. This is the DoD portion of the IDES process. So you'll have your VA examinations done, and then a DoD medical professional will review all your military records or service members' medical records, and they will also look at the VA exams, and they'll document a service member's medical status and determine whether their conditions or condition meets or fails the service branch's retention standards. And those retention standards are set forth in each of the branch's own guides. So there might be a guidance or issuance that says if you can't raise your arm more than 90 degrees, then you fail retention standards. And so long as you have one or more conditions that fail medical retention standards, your case is now sent to the second part of the DoD process, which is the Physical Evaluation Board. This is your more subjective board. It is comprised of officers and physicians, and they determine whether a service member is fit or unfit for duty. And that's a performance evaluation. It's the so what board. Why does the military care board? And so a service member who is, a special operator and requires certain physical capabilities is going to be judged differently than someone who does IT work and sits behind the desk, or better yet, an attorney, who still has to deploy, but might not have to do the same physical tasks, or doesn't have to do the same physical tasks as your operators. So a Physical Evaluation Board actually makes a determination of, can you do your job? Why does your condition that fails retention standards matter? If the PEB finds that one or more of your conditions is unfitting, you will get a rating from the VA, and it will be applied on the DoD side. So all those conditions you listed and claimed in step one, the VA examinations, the VA is going to issue you ratings for every single one. So if you claim 50 conditions, you're going to get a rating, or no rating if they say it's not service connected for all 50 conditions. The DoD is only going to adopt the ratings or apply the ratings for those conditions that prevent the service member from doing his or her job. So you could have a 10% rating on the DoD side and 100% rating on the VA side. And it's not that they rated the service member differently. It's just that they only found certain conditions to be unfitting for further service. Next slide, please. Okay, so determining fitness or unfitness. There's really 3 criteria for fitness. The first is you're unable to perform the duties of your office grade, rank, or rating. So we're going back to that example of the special operator versus the lawyer. There's going to be specific duties that are different for each of them. If you can't do the job of your specific, if you can't do your specific role in the military, you are unfit. They cannot say to you, well, you can do some other job. That's not the standard. So if you're a special operator, they can't say, well, you can now do administrative work. They have to look at you and judge your disabilities based on your particular grade, rank, or rating. Let's say that your condition is maybe volatile, or the service member's condition is volatile, or it's unpredictable. It's not always going to be duty limiting. It can still be unfitting if it imposes an unreasonable requirement on the military to maintain or protect the service member. So imagine someone who has a severe TBI, traumatic brain injury, and they can never get hit on the head again. They are able to do their job because their traumatic brain injury perhaps doesn't prevent them from doing like the mental parts of their job or even the physical, but there's no way for the military to protect them from never hitting their head on some piece of equipment or on deployment. Well, then they're unfit as well. And then the third standard for unfitness is the overall effect of 2 or more impairments. So imagine you have a back and a knee condition, and each one independently is not really a problem, but together, taken as a whole, they prevent you from doing your job or they impose an unreasonable risk. Well, then you're also unfit. So those are the 3 criteria that as an advocate, you need to look for. And then as a service member, you need to be asking yourself these questions. Can I prove this with my medical records? How do I show this? What can I give to my advocate? And so we talked about a condition as unfitting when you can't do the jobs, your military jobs, whether that's specific to you or also your basic soldiering duties, or if you're Navy, Marine Corps, your basic military duties and your physical fitness test. We talked about unreasonable burden and risk on the military. So that's Army or other branch, because I know there's lots of different branches on the phone call today. So the question becomes, well, how do I show what is unfitting? Other than you as the service member, you as the advocate saying this person can't do his or her job. So a way to show that a condition is unfitting is, for the Army service members on the call, is a profile. So a physical profile that limits your ability to do your job or to do a specific task. For Navy and Marine Corps, that will be, and actually Air Force, that would be a limited duty or some type of chit that prevents you from doing your job. Sorry. Medical notes, obviously. So if you're seeing a provider, having them document the notes that you want them to show the board. And then also commander statements are very helpful. So command saying, I've observed this service member unable to do this or that. And then finally, buddy statements, statements that from a friend or a colleague saying this service member can't do this or can't do that. Next slide. So we've talked a lot about medical retirement, and we talked about the benefits, just so you know the difference between a retirement and a severance. So like what happens if you get 30%, if you get 20% or less, you get a severance from the military. So rather than getting a retirement with TRICARE, retired ID, a possibility of combat related special compensation, which is an extra pot of money, as a severance recipient, you get a one-time cash infusion, and you can get VA care, but you're not going to get DOD care, and you can get VA disability payments. And I'm now going to turn it over to David.
Thanks, Esther. Next slide, please. So now we're going to discuss some IDES, quick tips and tricks for, both service members and advocates that, we've gained through our experience, through this process. We've broken this down, based on, where you might be in the IDES process. So the first set of tips, are going to be applicable to service members who haven't even started the process yet. So it's important at the outset of the process to define your desired outcome. So it's important to determine early on in the process whether you want to be found fit or unfit for military service. Because the earlier that you do that, the earlier that yourself and an advocate can work to develop evidence to establish that you either are fit or unfit. A lot of what we discussed through the presentation, is focused on being found unfit for military service because that's how you obtain a medical retirement. But of course, there are some service members who are going to want to stay in the military and be found fit for service. Being, found unfit is completely different than being found fit. So again, as soon as you can sort of make that determination, it makes it easier then to develop evidence for your desired outcome. And I would also say that if you want to be found unfit, then it's also good to start thinking about the injuries, that cause you to be unfit for service. And so, you may have 5 or 10 different injuries that you have. And so it's good to start trying to identify the main 2 or 3 that actually cause you not to be able to perform your job. Next slide, please. So again, at the start of the IDES process, a service member is going to have the opportunity to meet with a VA military service coordinator. And during that meeting, they will have the opportunity to fill out the VA Form 21-0819, which is a form that will go to the VA that will list any condition that the service member wants the VA to evaluate for potential VA disability compensation once the service member gets out of the military. This form is also important on the Department of Defense side because it will list the conditions that the service member thinks makes them unfit for duty as well. And so before the service member meets with the military service coordinator, it's a good idea for the service member or the advocate to obtain all the service member's medical records so that they can review them and determine, any condition where there is medical records that may establish that they have an injury that's caused by military service. Next slide, please. So again, at the process where your IDES hasn't started yet, during that process, the service member is going to have the right to be examined by the VA, and the VA will perform a compensation and pension examination for every condition that's listed on the VA form. And so those examinations are going to be important because they're not only going to assist the VA in determining the injuries that are caused by military service, but it's also important on the military side as well, because the military can use those examinations in determining whether someone is fit or unfit for military service. And so when the service member goes through these examinations, it's important that they, don't refuse range of motion measurements. So even if it's painful for you to do any range of motion measurements, let's say for the back or for the knee, you need to actually do the range of motion measurements, but indicate to the examiner that you're experiencing pain, or if you're experiencing other symptoms, it's important that you report that to the examiner so that they can list that in the examination report. Also, don't ever over or underperform during the examination intentionally. So just do the range of motion, as you can do it. Don't try and, sort of underperform if you can do more, because the examiner will probably pick up on that and they could include that information in the examination report. I think this is probably the most important tip here, and that's don't try and suck it up during the exam. Don't try and act like, you're the hero that you are, being in the military. You need to just report any condition that you have, any symptom. Now is really not the time to not report those symptoms. And of course, don't miss the appointment. If you are going to miss the appointment, then, please arrange or reschedule it with the VA. Just, provide some sort of reason why you need to reschedule the appointment. Next slide, please. So you're still in the process where your IDES hasn't started yet. So everyone has the right to seek counsel, whether that's from a military lawyer or from a civilian lawyer at your own expense. NVLSP, the National Veterans Legal Services Program, we provide free legal assistance for this IDES process. So please, if you need assistance with this process, please reach out to us. When you're meeting with your counsel, of course, the earlier that you meet with your attorney, the better. So, don't wait to either seek assistance from an attorney or to schedule an appointment with counsel to discuss the IDES process. Of course, when you meet with your counsel, be able to provide them with any releases for them to obtain your medical records. Also, let them know about any correspondence from the Medical Evaluation Board or the Physical Evaluation Board. And then also, as the service member, you are really your best advocate, through this process. So as the service member, you can start obtaining supporting documents, whether you want to be found fit or unfit, either requested by counsel, or even if your counsel doesn't ask you to, if you think that there's an important document that can help with this process, please engage with your counsel about that document, and provide any other supporting documents that you think may be helpful to your counsel as soon as possible. Now I'll turn it back over to Esther to discuss more about the IDES process.
Thanks, David. So now I'm going to discuss what an advocate or a service member should do if they are at the MEB. And remember, this is our more objective board that talks about retention standards. So when you are going through the MEB, the first document you're going to get is called a narrative summary or an MEB report. And you have a right to ensure that the MEB document documents all of your medical conditions and your entire medical history. Even if that condition does not fail retention standards, it should be at least discussed and considered. That being said, the advocate or the service member has the responsibility to review the narrative summary or MEB report and ensure it addresses all the conditions and symptoms. At the end of the day, no one, including a physical evaluation board liaison officer, PEBLO, or an attorney or an advocate, knows your medical history better than the service member or his or her caregiver. So it's the responsibility of the service member to make sure he or she reviews the document and that all of the relevant conditions are documented. I think there's still like animation, so you just hit, yeah, perfect, great. No, thanks, Matt. So the other thing to look at when you're at the MEB is you need to look and see. A common complaint that we often have is my NARSM, my narrative summary, my MEB report is missing facts, or the diagnosis is wrong. The VA diagnosed it as this thing and the DOD diagnosed it as this, and the service member is understandably upset. But that doesn't always mean that we need to appeal. We need to really look at the narrative summary because you want to appeal when there's something that's going to benefit the service member. So as an advocate or the service member looking at him or herself, you need to see, does it matter that there is this mistake? And so you need to make sure at a minimum that the diagnosis and NARSM address the body part affected. So you can't be found unfit and rated for the same knee condition twice, or the same head condition. So it's what's most important is that the body part and the limitations are most documented, or that are documented correctly. And so those are things to consider when you're weighing when to appeal and when not to appeal. Next slide. So the other right that service members have at the MEB is to have the military consider each VA diagnosis as potentially medically unacceptable or duty limiting. However, service members and advocates need to recognize that having a diagnosis does not make a condition medically unacceptable or duty limiting. You have to obtain documentation from your medical provider and your command that shows how your condition prevents your further service. So when you're at the MEB, if a service member is at the MEB, the service member or the advocate should consider whether the service member is at a medical retention point, like at a point where they can determine whether the condition is duty limiting. Has the service member been provided optimal treatment? Has the service member documented it with their medical providers? And it's important to have your records in front of you to be able to do that. Next slide. And so a common complaint we get at the medical evaluation board is the service member or an advocate will look at the documentation and will say, oh, we're missing something. And so the service member will go to the doctor or the commander, and the commander or the doctor will say, I'm not going to provide the documentation that you need. Unfortunately, there is no way to require a commander, your doctor, or any other military personnel to provide a documentation. So you need to then, the service member or the advocate needs to get a second medical opinion, reach out to another officer or non-commissioned officer to get that documentation. There's no legal remedy to say, hey, doctor, hey, command, write this way. Next slide. So service member and the advocate have reached the physical evaluation board stage. And remember, the physical evaluation board stage is the why does this matter stage. It's the part where the military looks and says, why does this condition prevent this particular service member from doing his or her job? And we, as attorneys, often have the most common complaint at the physical evaluation board from service members is, my friend has the same condition and it's unfitting. Why isn't it my condition? Or, their PTSD prevents them from doing their job. I have PTSD. Well, so the thing to remember is, don't listen to a barracks lawyer. Go talk to an actual attorney, someone from NVLSP, someone from judge advocate's office, someone from a law clinic. You need to get actual legal advice. The second thing to remember is that identical conditions can have different effects. So, one leg injury might affect one person one way and another person another way. And since the physical evaluation board is determining, does your particular condition prevent you from doing your job? That's how the same condition can be fitting in one person and unfitting in another. And remember, fitness depends on your military occupational specialty, your rank, and your symptoms, not just your diagnosis. So, if your friend says you should be unfit for this condition, that might not be true. You should speak to an attorney. If you're at the physical evaluation board, make sure you get legal advice. If you disagree with your PEB findings, talk to an attorney. Even if you agree with your findings, talk to an attorney and make sure there's nothing that's a red flag. But if you disagree with your physical board evaluation findings, you need to reach out immediately to an attorney and get help to prepare for a written or formal hearing. because there is advocacy that can be done, and there can be new evidence that can be collected all the way up until the day of the board. So you need to be proactive in reaching out to an attorney. So one of the other things that is, pretty confusing that we've touched on before is DoD versus VA ratings. And so one common question we get is, why is my combined VA rating so much higher than my DoD rating? And we had discussed this a little earlier, but the VA rates any condition incurred or permanently aggravated by service with symptomology. The DoD only applies those ratings for unfitting conditions. So if you look at the chart that we have provided, if a service member claims their ankle, their knee, and their PTSD, but only their ankle and their knee is unfitting, they're going to have a higher rating for the VA than from the DoD. And if you're looking at the math and you're like, how is a 50 and a 10 and a 10 a 60? It's that VA disability calculations are not based on the sum of each percentage. So that's not a typo, it's just the way the VA math is done. So let's say you're at the physical evaluation board and you agree with a service member and advocate agrees that the PEB has correctly identified those conditions which fail medical retention standards. There is a disagreement with a rating. If you disagree with a rating, the appeal is actually not to the Department of Defense. If the rating is for a condition that is unfitting, you get a one-time appeal while still in the military to have the VA reconsider the rating for your unfitting condition. So if you get a 30% for your unfitting PTSD, you can appeal to the VA while still in service for a higher rating prior to discharge. And if it's increased, your disability requirement will be based on that new percentage. However, let's say you're found unfit for your PTSD and nothing else, you can't ask the VA to reconsider your knee condition until you're out of service. So if you, as an advocate or as a service member, contact your attorney, you should contact your attorney with any and all supporting documents to draft a VA ratings reconsideration. A lot of times that requires new ranges of motion, new documentations of symptoms, but you can change your rating for your unfitting conditions one time prior to getting out, and it will have effect on your discharge, type of discharge. Next. Okay, so when you're at the physical evaluation board, the physical evaluation board is going to either place you on the PDRL, permanent disability retirement list, or the TDRL, temporary disability retirement list. And we often get the question, what is it and can I avoid it? So the temporary disability retirement list is a list that service members are placed on when their condition may get better or worse over the next 3 years. So the rating for that condition and the fitness determination is temporary. It means the service member will be retired at least a 50% disability rating, but that he or she will have to get reevaluated by the physical evaluation board in the next, usually year, but can be up to 3 years. And the reason that the military does this is to ensure that someone isn't separated with a rating that it doesn't reflect their permanent disability. There is one or two conditions that almost always require TDRL. And the biggest one is post-traumatic stress disorder, especially when it's based on combat or when it's based on military sexual trauma, or really if it's based on anything, is the idea being that your disability could change once you're out of the military or out of the environment, for better or worse. And no one wants to go back through a physical evaluation board after they're out. No one wants to be retired and then lose that retirement later on. So the big question is this avoidable? And the answer is, unfortunately, the only way to avoid it is if you can show, by a preponderance of the evidence, by the majority of the evidence, that your condition is stable for rating purposes, meaning that your condition won't improve or worsen over the next 3 years. which for certain conditions which are inherently volatile, that's pretty much impossible. Okay, so you're placed on the temporary disability retirement list, and one of the concerns of a lot of service members is they're worried that their rating will go down. To ensure a rating is correct, the biggest thing a service member can do, or who's now a veteran, is to go to all the medical appointments for your TDRL condition. And that means not just the new DoD exam when it's scheduled, but all of your treating providers' medical appointments. And you should save any and all documentation from that treatment. You should document any occupational restrictions on the civilian side due to your condition. And finally, you should schedule a VA exam close in time to your DoD TDRL physical. And the reason for all of this, for saving your documentation, for getting a VA exam, for showing occupational restrictions, is that if your rating does go down, or if you are found fit for duty for a condition you were previously found unfit for, you'll have documentation to appeal. But if you don't go to a medical provider between your placement on the TDRL and your reevaluation, and you don't like the results, you'll have no evidence to combat those results without medical documentation from another provider. Moreover, the best way to show that a rating is incorrect provided by the DoD is to have a VA rating close in time to your DoD TDRL physical to say, hey, look, this was done, very shortly before this hearing, and look, my rating has been unchanged or has gone up from the VA. So NVLSP does a lot of IDES work. That's a picture of myself, two partners from a law firm, and a SWIC crewman. You'll see this was after a hearing that we won. He incurred a TBI when his craft experienced a bow plunge at about 50 miles per hour off the coast of Iran. He was submerged along with the craft, completely underwater, and he was found fit initially by the physical evaluation board. So the board said, your dizziness, your migraines, your vertigo left him, he could still do his job. Under the fitness standards, one can only imagine that that was not compatible with service because he was unable to, he was never cleared to go back on a boat, which was necessary for his rate. And he couldn't work more than 24 hours in a week in any capacity. Moreover, with his traumatic brain injury, he couldn't risk getting another blow to the head. Nonetheless, even though it seems quite obvious he was unfit, the PEB initially found him fit for duty. So NVLSP and pro bono counsel represented him before the formal physical evaluation board at Navy Yard in DC. And he was found unfit for TBI with vertigo of central origin and migraines. And his condition was found combat related. So we were able to help him with combat related special compensation. So I guess the main point of the story is NVLSP can help, but also that if you're sitting in a situation and you're unhappy with your PEB results or your DES processing, there are things you can do to change it. And I'm now going to pass the baton on to Rochelle.
Thank you, Esther. So we're going to talk about Board for Correction of Military and Naval Records. I have a quick housekeeping task that I want to just take a quick moment for our volunteer attorneys to mention a code word that you need for your CLE affirmation forms, and the code word is service. If you are not our pro bono attorneys, you do not need to worry about this, just disregard. If you are a pro bono attorney looking for CLE, the code word is service. So now I'm going to go back to the slides and talk about the boards for correction of military naval records. So this is after discharge, and the bulk of the work that we do for medical retirement is at these post-discharge boards. So each military branch has a board. Just check again, my video's on, has a board. It's either the Board for Correction of Military Records or the Board for Correction of Naval Records, where if you did not obtain a medical retirement during your service, then you can submit an application for medical retirement. And in this picture, you see a veteran who came to us meeting with 2 pro bono attorneys at a clinic back when it was safe to all be together. Next slide, please. So our post-discharge work generally can be divided into 2 buckets. So the first bucket is where a veteran was provided some processing, but did not get a medical retirement. So this usually happens in one of 2 ways, where the PEB fails to identify all unfitting conditions. So just to give some examples, this would be where they find that some physical conditions are unfitting, but they say the mental health conditions do not render the service member unfit. We also see unduly low ratings. The military gives a 10% rating when the person is completely incapacitated by that particular illness or injury. And so those are cases that we handle regularly at the post-discharge boards. We also assist veterans who never had any disability evaluation system processing. So this may be that they are sent out of the military at the end of their term of service, even if they've been on a profile or in the Army or in the Navy, limited duty, LIMDU. They've been on LIMDU for a year and nevertheless are never sent into the disability evaluation system process. They're just said, okay, your term's up, goodbye. Those people may be good candidates to apply for post-discharge relief. We also assist veterans whose injuries caused misconduct that resulted in an administrative separation. So for instance, perhaps a service member had severe PTSD, post-traumatic stress disorder, from combat or from military sexual trauma, and they did something that was misconduct, let's say popped hot for marijuana, or did not show up on time because they were traumatized and couldn't sleep and couldn't wake up. Sometimes the injuries may result in misconduct, but we see cases where the disability evaluation system processing grinds to a halt. We also see cases where the administrative separation and the disability may continue, but then the administrative system prevails. So we sometimes assist those veterans post-discharge. We also take cases where the military wrongly determines the service member's injury is not a compensable condition. The most common example here is personality disorder or adjustment disorder. You have a service member serve for 10 years. They go into combat 4 times. After the 4th one, they've got PTSD and are having all sorts of mental health issues. And rather than send them into the process for disabilities, they get labeled with a personality disorder and they're out in a month or 2. Which is much, much faster and easier for command, but is simply wrong. So we will take personality disorder cases. Again, we review all medical records. We do not simply take all cases. So, but those are the types of cases that we take. So what does it mean to seek this type of post-discharge relief? If you're going to go before 3 civilians in a grade of GS 15 or above, this review is going to be records review only. So whereas, Esther was just describing a successful case where she was at a live hearing, the BCMR and BCNR, it's a records review. And so documentary evidence is really important. While they're going to have a personnel record, they may not have access to all your service medical records, and they may not have focused on the most helpful documents. But the burden of proof is on the veteran to prove that there was an error or injustice. The boards will presume that they did everything right. the legal term is administrative regularity. So you can't just come in and say, we think, we think there was an error. You have the burden of proof here as the veteran to show that the decision below was wrong. There is a statute of limitations, which is a time period you have to file within, and it's 3 years after an alleged error or injustice is discovered, but it can be excused in the interest of justice. We generally say for people who come to us that the error is or was discovered after NVLSP was able to review the files and say that we as experts found an error. And in virtually all of the cases we have filed, the boards have excused any delay, understanding that a service member or veteran didn't have the kind of expertise to know what's an error or injustice. So how does one apply to the BCMR? There's a form. Next slide, please. And that is the form 149. But it's also important to have evidence because, as I just said, the burden of proof is on the veteran. So a commander statement can be helpful, the MEB, narrative summary, NARSUM, or report, any kind of documentation that the military said you cannot do your tasks. So it could be a physical profile or limited duty, depending on your branch, or an MEB report. Records, medical records, either from the Department of Defense or the VA, those often support medical retirement. Personal statements, lay statements can also be helpful. And sometimes a new medical opinion may be a critical piece of evidence depending on what's missing. Next slide, please. So in terms of tips and best practices, focus on what happened in service. This is totally different than VA. For the VA, you can have 100% of symptoms not starting until 10 years after service. Well, that doesn't work for a medical retirement. It has to be in service, and it has to relate to the military duties. It can't just be something that gives you, pain. It has to relate to what you had to do in service. And it's really important to keep in mind the magical number of 30%. If it's only a 10% or 20%, that's not enough for medical retirement. And you want that rating to be within a year of discharge. Otherwise, you're probably going to need an independent medical expert to assist. And this could be a rating going back to the effective date of discharge, but best and strongest evidence is an actual rating from the VA, either at the time of discharge or shortly after discharge. Those are your best pieces of evidence to help with getting a medical retirement post-discharge. So I'm going to share a special, I'm going to share a success story that NVLSP had, where it was an Army combat veteran with severe PTSD from traumatic events in Iraq. And our pro bono attorneys prepared a brief. We gathered medical evidence and submitted all that to the Army Board for Correction of Military Records. And the board overturned previous decisions and granted the veteran a permanent disability retirement due to his PTSD. So we do get successful results through this process, and success can mean eligibility for combat-related special compensation. So David Sonnenschein will talk about that, and the next slide shows me at a clinic in Los Angeles with some veterans. So David, turning it back to you.
Thanks, Rochelle. So yeah, now I just want to take a few minutes and discuss combat-related special compensation. It is one of our most popular and successful programs at NVLSP. So first, what is combat-related special compensation? Well, Crsc is an extra monthly payment provided by the Department of Defense that it's available to eligible veterans who have injuries that are combat-related. So it's essentially an extra payment that's available to eligible veterans who have injuries that are related to combat. This payment would be in addition to any military disability retirement pay or VA disability compensation that the veteran may be receiving each month. Next slide, please. So who is eligible for CRSC? Well, the main eligibility requirement for CRSC is that you have to be retired from the military. You could be retired due to disability, or you could be retired due to longevity. But as long as you're retired in some way, shape, or form, then you are potentially eligible for CRSC, as long as you then can show that you have injuries that are related to combat. Next slide. So what type of injuries or conditions are eligible for combat-related special compensation? So essentially, any injury or condition that is service-connected by the VA that has a disability rating of at least 10% is arguably eligible for CRSC, as long as you can show that, again, that condition is related to combat. So in the example here, we have service-connected PTSD at 30%. That's obviously one that should be submitted for a claim for CRSC. Back pain at 20%, also tinnitus at 10%. Those are also potentially good claims to submit for CRSC. But the hypertension at 0% is probably one that I would say we should not submit for CRSC, just because it has a 0% rating and cannot really factor in to the overall compensation for CRSC with a 0% rating. Next slide, please. So how does the military determine whether a condition is combat related or not? Well, there's 5 different categories of conditions or injuries that the military considers are related to combat. So the first category is injuries incurred as a direct result of armed conflict. So this category is meant for injuries that were incurred while someone was deployed. So let's say to Iraq or Afghanistan, if there's an injury from that deployment, let's say there was a blast from an improvised explosive device and there was a physical or mental injury that came out of that, then we would potentially claim that injury under the category for direct result of armed conflict. The next category is injuries incurred through an instrumentality of war. Now, this category is extremely broad in the sense that it covers injuries incurred on a deployment and also injuries that were incurred stateside as well. Injuries incurred through instrumentalities of war can be injuries caused by, weapons fire. So if you have hearing loss from working at a firing range, then the weapon could be the instrumentality of war, that obviously caused the hearing loss. So we would potentially submit a claim for CRSC for hearing loss under the instrumentality of war category. The next category is injuries incurred in the performance of duty under conditions simulating war. So this is a much more narrow category in the sense that there has to be an injury caused by a training environment that was simulating armed conflict. So it has to be a training environment like a live, war games exercise, something with live fire. But the key for this one is that the training must be simulating war. So injuries that were caused by just doing normal physical training, or maybe a field exercise that really wasn't geared towards, a deployment, then, potentially that injury would not fall under the category of injuries caused by the performance of duty under conditions simulating war. The next category is injuries incurred while engaged in hazardous service. So this category is meant for injuries caused by performing like airborne exercises or doing deep dive duty in the ocean. So it has to be something that's extra hazardous than just normally serving in the military. And then finally, injuries for which the member was awarded the Purple Heart. If you were awarded a Purple Heart for a specific injury, then for the most part, that injury is going to be approved for combat-related special compensation. We just have to show that, the veteran received a Purple Heart and the injury that resulted in the veteran receiving the Purple Heart. Next slide, please. So evidence to submit in support of a CRSC claim. So just like anything else, the burden is on the applicant to prove a claim for CRSC. So, you're going to want to submit all evidence that would support, that a condition was caused by combat or an instrumentality of war or training simulating war. So some important documents for that can obviously be, a Purple Heart certificate or other award citations. Of course, the DD Form 214 or discharge certificate would list any award citations and also would list any deployments. Any VA rating decision that describes how the injury was caused and, that actually lists the disability percentage. The physical evaluation board findings, the medical evaluation board narrative summary. Those documents often will include information about how injury was caused. And so, that can be good information to show that an injury was caused by combat. And then, just, any medical records, again, that focus on not necessarily the symptoms or sort of what the veteran is experiencing, but more medical records that, again, show how the injury was caused are going to be the best evidence to submit in support of these claims. Next slide, please. So how does one apply for CRSC? Well, all you have to do is complete a CRSC application form, which is DD Form 2860. That application form must be filed with the service branch that the veteran was retired from. In addition to submitting the application form, we obviously advise that you submit any supporting medical evidence, lay statements, any supporting documents that help show how an injury was caused and how that injury is combat related for CRSC purposes should be submitted in support of the application. Next slide, please. So a combat related special compensation success story. So this is one where we were able to assist the veteran not only with combat related special compensation, but we also assisted this veteran through the IDES process as well. And so we helped an Army Staff Sergeant who served in Iraq and injured his back and shoulder during an improvised explosive device blast. We were able to assist the veteran in completing the application form and also developing, documents and other evidence to submit in support of the claim. Thankfully, we were successful, and now that veteran receives an additional $1,000 per month and also obtained a retroactive reward of $17,000. So CRSC, you can receive payments moving forward, and there also may be the potential for a retroactive award as well. Next slide, please. So again, here's our contact information for our completely free legal services. Again, we provide free legal assistance for service members going through the IDES process. We also provide assistance for veterans who are applying to a board for correction on military records or naval records, trying to obtain a retirement that way. And then, of course, we can also assist with applications for combat-related special compensation once you are in a retired status. Next slide, please. So questions. We are available to answer any questions about medical retirement, the board for correction of military or naval records, and combat-related special compensation.
I had a question, curious to see if you guys had dealt with assisting any of service members submitting their continuation of active duty service or COAD, if they're going through the MEB, PEB process while they're between 18 and 20 years of service.
So we've done COAD packets for people that we've assisted with COAD packets for people that are IDES clients. Not as like a separate program. The reality is that, you need the command support. Without it, you're pretty much dead in the water. So that recommendation, and then getting it all together, and then, you know, showing the need. But if you have that command support in general, we find that it's less of an issue. But I did that a lot also while I was working as a judge advocate for the Army. Is there anything specific?
Yes, and I also have an appointment set
Perfect.
Friday that I can go in more detail. I just wanted to throw a general question out there initially.
Okay, great. We'll go over the specifics on Friday.
Okay, thank you.
Looks like there's a question in the chat. How do you approach a case where the veteran was administratively separated while they were going through a med board? Esther, you want to take that?
Sure. So I'm assuming based on this conversation that the service member was administrated, like they were out while they were going through a med board. So each of the branches actually has their own regulation that deals with dual processing. Depending on the branch, so the Marine Corps and the Navy let you go all the way through the DES process, and it has to go to personnel comm, so it has to go above your command to get that approval to separate someone. In terms of the approach to the case, we handle both sides, the administrative and the IDES, in a select number of cases, usually where there's severe combat trauma or trauma from a military sexual trauma. In fact, McGuire Woods and us are currently representing and have previously represented service members in this process. So the approach really is, the biggest thing I can say the approach is in handling this is showing the nexus. There is going to be no possibility of being able to have so at the end of the day, all the branches of service require that there be a nexus. There should be a reason for why the medical condition caused or contributed to the misconduct. So the first approach that we always do is trying to get that nexus statement, working with the service member, their psychologists, it's usually mental health as a reason. We do sometimes see pain and self-medication, but approach is, if we have a nexus statement and that we can support it, we can make an argument that the medical evaluation board should take precedence over the admin board. And where someone's already been separated, which it looks like in this question they were, we would make that argument to the Board for Corrections of Naval Records or the Army Board for Correction of Medical Records.
We had a question about common problems in IDES, asking, even going to procedural issues for Congress, which I don't think we want to go quite that far. But one of the common problems is the dual processing issues, where people are given an admin separation. And we believe that there was good evidence that the misconduct was caused by the mental health. We also talked about the presumption of administrative regularity for post-discharge problems. Esther or David, is there some other common problem you would want to briefly mention?
I think the biggest problem is on the dual processing issue is that the guidance that applies to the boards for corrections. So if whoever's asking this, I'm assuming, is familiar, there are memos written by the Department of Defense that say certain special consideration and liberal consideration be applied, and that doesn't apply in service. So basically it only applies once it's too late. And so the discretion by which the boards look at whether to pick an MEB or pick the administrative separation, you don't get that liberal consideration until you're out. And that's a problem. In terms of, I would say the other issue, and then I'll let David take it, is that the adjudicators, there's human error. You have 3 service members sitting on a board, or in the case of the Army, sometimes it's 2 service members and a civilian. for whatever reason, there is not a uniform, like the same case, the same facts can have totally different outcomes depending on who's sitting on the board. And I don't think that that will be remedied unless there's larger legal oversight or there's some other way of enforcing the correct standards until there's some more oversight on the boards themselves.
Yeah, I would just put out one additional issue, and that would be the temporary disability retirement list, or the TDRL. You know, the IDES process where, you know, the military determines whether a condition's unfitting and the VA rates the condition. You know, that's really not how it is when someone's on the TDRL. When the person goes on the TDRL and comes back up for a re-examination, the military is then, you know, in pretty much complete control to rate the condition. And so I would say that, you know, we should put the same protections, you know, on the TDRL side that we have, you know, on the initial process, where the military should be bound by the VA's rating of the condition while the veteran is on the TDRL.
I think we are going to need to bring this to a close. So I want to thank everyone for participating. Please feel free to reach out to us at the info@nvlsp.org. If you have further questions, that's the best way to get a hold of us. And also the best way to apply for our services is through the online portal. Thank you all so much for joining us, and we wish you all the best.